Welcome everyone to our preview of this year's Changing Currents in Employment Law, the DC Bar's Fall Employment Law CLE. I am Scott Oswald. I am Faculty Chair of Changing Currents in Employment Law. And today I am joined by Jennifer Everett. Jennifer is a partner at Jones Day in their DC office, and Jennifer is moderating and will be co-moderating a panel on vulnerable to attack. The growth of cybersecurity whistleblowing. Jennifer, hi.
Thanks so much, Scott. It's a pleasure to meet everyone, and I look forward to the panel coming up and chatting with everyone about this fantastic and actually very timely topic. You know, from federal agencies to private hospitals, really the past year has demonstrated the growing sophistication of cybersecurity attacks and the need to safeguard data and networks from potential threat actors. So during our panel today, myself and my other co-panelists, we'll be talking about not only sort of the risks associated in terms of this ever-changing environment, but also about the risks with, possibilities of potential whistleblower initiating what's called a false claim action on behalf of federal government, and exploring what those initiations, those claims may look like, and what companies in particular can do to mitigate, prepare, and respond to not only the cybersecurity threat, but to the federal government's increasing sort of, focus on protecting data. I look forward to speaking to you about this panel, about this topic.
So the federal government, right? I mean, one of the problems to the federal government is it's responsible for its own networks, but there may be a potential vulnerability with one of its contractors too, right?
That's correct. That's exactly correct. And because of that, right, the contractors are themselves not only subject to their, cybersecurity requirements by way of contract, for example, but again, the government is increasingly focused on cybersecurity risks, increasing cybersecurity measures, and of course, reporting requirements in the event that there's a vulnerability or potential issue. Likewise, companies or individuals are empowered by the False Claims Act in particular to file or raise a claim in the event that there's noncompliance. So you're exactly right, Scott.
So let's say I'm in the audience, I'm attending your panel. Maybe what are one or two takeaways that I might take with me after the panel, after hearing your presentation?
Great. So just a couple of points. First, for anyone who's listening on the panel, my co-panelists and I will be giving you an overview of the False Claims Act, or the FCA, which imposes liability on anyone who knowingly uses or cause abuse, sort of a federal statement or a false record. We'll likewise be talking about, and particularly my co-panelists will be focusing on the possibility for, the whistleblower themselves or private persons referred to as key team relators to initiate FCA claims and actions on behalf of the government. Then we'll go into a deep dive into really these cybersecurity requirements that we talked about earlier, the government's focusing on.
So Jennifer, what's the kind of advice that you're giving to your clients right now, especially federal government contractors who might be dealing with issues relating to cybersecurity breaches?
Great question, Scott. Cybersecurity compliance, as I said, is a really increasing enforcement area. And this really just is not in connection with data breaches, but also with respect to representations that are made to government. Put simply, there is liability for false cybersecurity certifications, and those are not dependent only on data breaches. Companies can be guilty of violating the FCA even when they're providing non-conforming products absent sort of a technical failure. So it's important to remember that it's not just the data breach that can get someone into potential liability or harm or other reporting requirements, but it's also the representations that are being made with respect to the product or the services. So we're encouraged very carefully at what cybersecurity controls that they have in place and ensuring that they are able to actually beat the representations that they're asserting, right? This means that they should be carefully thinking not only with respect to strong internal reporting, remediation efforts, but also sort of thinking carefully and having a response reporting place in the event that there are possible vulnerabilities, so that individuals who are close to or have some familiarity with the product or services have a means to raise or address potential claims or concerns so that the company can A, be aware of vulnerabilities, 2, mitigate, and 3, give employees a way, sort of means to be a part of and ensure that we are not making any false representations to the government with respect to the product or services. Also
And
important
Jennifer,
to
when
keep,
employees aren't, they don't feel like they're being heard, that's what leads to whistleblowing, right?
that's exactly right. It's important to remember, Scott, that retaliation against whistleblowers is prohibited under several enforcement schemes, including the FCA. So again, having a strong sort of internal robust reporting space that will allow whistleblowers or individuals a way to raise potential claims and help mitigate the potential for any sort of FCA claim.
Jennifer Everett, we are so grateful to you. Look forward to your and Colette Matzie's presentation, and we look forward to seeing each of you at this year's Changing Currents in Employment Law on Tuesday, October 26th at 6 p.m. You can find us at dcbar.gov.
Thanks, Scott.